Hey folks, let's talk about a post that caught my eye on Bluesky this morning. A response to something I wrote about Mahmoud Khalil. Take a look. Precognitive speech isn't protected either. How does the GOP not understand that the First and Fifth Amendments do not require citizenship? Now, you've probably seen takes like that all over your feed. That's not what the Constitution says. Can't they read? Well, here's my take. And yeah, we're heading back into the tunnels of resistance history, which is where almost all of this stuff is coming from these days. They do understand. They just don't care. And that's what makes this even more dangerous. The ultra-nationalist coalition clawing for power, those remaking immigration policy to serve their fragile, empty, white grievances, they're not misreading the Constitution. They're just betting you haven't read it. Or if you have, that you don't know what happened the last time Americans tried to make rights permanent. These people are not confused. They're confident. They know their white history, but they know their black history too. They know that rights, even constitutional rights, are only as strong as the courts that interpret them, and only last for as long as a court is willing to uphold a thing that we used to call precedent. It used to be binding. It's not anymore. And they've already stacked the courts with people eager to gut those rights, those exact rights, quietly and with citations. Trump's judicial appointments from 2017 to 2021, 3 Supreme Court justices, Gorsuch, Kavanaugh, Barrett, 54 appellate justices, nearly 30% of the entire federal circuit courts, and 174 district court judges. And many of them were handpicked for their alignment with foolish things called like the Federalist Society and its crazy orthodoxy, textualism, and mostly originalism with a deep hostility towards substantive due process. They don't need to rewrite the First or Fifth Amendments. They just need their judges to reinterpret them, exactly like American courts did with the 14th Amendment. So let's rewind. After the Civil War, Congress passed, obviously, the 13th Amendment to end slavery, but then the Civil Rights Act of 1866 to make sure that formerly enslaved people were protected. The Civil Rights Act of 1866 was the first federal law to define all persons born in the U.S. as citizens and guarantee them the same legal rights as white Americans. Congress passed it over a presidential veto from that paragon of virtue, Andrew Johnson. And that was the first sign to radical Republicans like Bingham and Stevens and Sumner and Trumbull that statute law wasn't going to be enough. They knew it could be repealed the moment that the rebels returned to power, or the moment that courts just chose to kill it. So they wrote the 14th Amendment. They wanted to write the principles directly into the Constitution and get rid of that Patriots' Republic once and for all. Birthright citizenship, due process, equal protection under the law for everybody. So there's the 14th Amendment ratified in 1868. But permanence is a tricky thing when it comes to American constitutional history and jurisprudence. Within 5 years, the Supreme Court had gutted it. The Slaughterhouse cases of 1873. It narrowed the Privileges and Immunities Clause so dramatically that it became meaningless, protecting only federal rights like accessing ports or federal buildings, not civil rights across the United States. 1876, United States versus Cruikshank. It held that the federal government could not prosecute white terrorists for the Colfax massacre, where over 100 black men were murdered. The court said, 14th Amendment doesn't apply to private actors. And then Plessy versus Ferguson 20 years later, 1896. It sealed the deal with constitutional apartheid. Separate but equal. It was ruled lawful under the 14th Amendment. And those 3 rulings, Slaughterhouse, Cruikshank, Plessy, turned the 14th Amendment into just this cemetery of words. All the language was still there. It just didn't mean what the people who wrote it intended it to mean. Black Americans were still citizens. They still had equal protection and due process, but only on paper. Paper doesn't protect you when the courts side with power. Even Justice Harlan's famous dissent in Plessy, and all of us who went to law school are all over this dissent. This is the one that we love to quote for its line about the Constitution being colorblind. But that was no clean endorsement of reality, because context is everything. You got to read the next line, the very next sentence. He wrote, after the Constitution is colorblind, he wrote, "There is a race so different from our own that we do not permit those belonging to it to become citizens of the United States." He meant Chinese people. He praised their exclusion as good policy. And that was the best of it. So even in the most admired dissent of the era, equal protection had limits. And those limits had a skin color. They were racial ones. And it took 58 years to undo Plessy with Brown versus Board in 1954. And even that decision only struck down school segregation, not housing, not transit, not jobs, not justice. And it took President Eisenhower sending the 101st Airborne Division to Little Rock to enforce that decision. 10 years later, it took John F. Kennedy deploying 127 U.S. Marshals, 316 Border Patrol officers, and over 3,000 troops to get James Meredith enrolled at the University of Mississippi. And those were just the headline battles. The rest of Jim Crow, legal and extra-legal, marched on for another decade, and some would argue that it's not over yet. And then there are the Insular Cases. So those are a series of Supreme Court rulings between 1901 and 1922 that made it clear that constitutional rights don't travel with the flag. The court ruled that full protections under the Constitution didn't apply in U.S. territories like Puerto Rico, Guam, American Samoa, and the Philippines, because they were, quote, inhabited by alien races, end quote, who might not understand, quote, Anglo-Saxon principles, end quote. It's not a paraphrase. That's direct from the court's reasoning. The Insular Cases turned race, geography, and colonial status into legal justifications for suspending the 14th Amendment. People born in U.S. territories were told, you may be under the flag, but you're outside the Constitution. And they still are. More than a century later, the Insular Cases are still binding precedent. They have never been overturned. That means millions of people, American nationals, born in U.S. jurisdictions, live without full constitutional rights because of rulings written in the language of white supremacy and imperial control. The Constitution didn't fail. It was interpreted to serve power, and the courts made it stick. So when people ask how this can happen again, when they assume the Constitution will protect them, the answer is it never really has, not when white power was on the other side of the line. So what's happening now with Mahmoud Khalil, a Palestinian man the government is trying to deport not for what he did, but for what they think he might believe as a student, is not an aberration. It is absolutely consistent with our constitutional history. In fact, it's been the rule. The Alien Enemies Act of 1798 gave the president authority to expel any foreign national from an enemy nation, even without evidence. The Espionage and Sedition Acts, 1917, 1918, criminalized dissent. The Palmer Raids and the Immigration Act of 1924 turned radical beliefs and foreign origins into legal grounds for surveillance and expulsion. The Internal Security Act of 1950 and the McCarran-Walker Act of 1952 allowed deportation based upon ideology. And Executive Order 9066 gave us Japanese internment. Korematsu versus the United States upheld it. All of it was lawful. All of it was constitutional. So yes, the First and Fifth Amendments don't require citizenship. But don't take comfort in that. Because what courts can reinterpret, governments can then exploit. And the far-right coalition driving this moment knows the history. They know that rights are not self-enforcing. They know most Americans don't remember this legal history. They know they don't understand their own Constitution. They know that with the right judge in the right circuit, they don't need a majority in Congress. They don't need Congress at all. They just need one ruling. And that's why they're fishing around for it in every jurisdiction they can. Because eventually they will get to the right judge. What happened to the 14th Amendment is happening again. Only now it's the 1st and 5th being rewritten, and they'll get back to the 14th too. So beware of asking why they don't understand the Constitution. They do. They just understand what it's always been used for, preserving white power. They know what they're doing. That's why they don't care. But we know too. And that's the one thing authoritarianism can't survive. The loss of control over the lie. It depends on cutting you off from what's true, on flooding you with distortions and then calling it history, calling it legacy, on hiding behind Louisiana courts and El Salvador prisons. So we shine the light, we learn, we share, we call it what it is. We turn every act of understanding into an act of resistance, even if it's a micro-resistance, even if it's just you saying on your phone right now through this lens, not this time.